Good afternoon, sir. Allison Munroe. I'm instructed by Birnberg, Peirce, and also Deighton, Peirce, Glynn. And I should say at the outset, sir, that the submissions that were filed on behalf of Birnberg, Peirce are adopted and supported by Deighton, Peirce, Glynn. So the matters that I propose to deal with very much dovetail and overlap on the very comprehensive submissions that have already been made this morning by the advocates representing a number of core participants who are the next of kin of deceased, survivors and residents. And it cuts across, or they cut across rather, those fundamental, I say, principles and legal submissions that have been made in relation to Article 2, to the question of appointing a panel, and the structure of the inquiry, and indeed disclosure. So in addressing you, I hope to deal, concisely and comprehensively, but concisely, with 4 points. Article 14, the public sector equality duty, the question of diversity and inclusion, and finally the issue of venue.
Yes, all right, thank you.
So I hope what I say is constructive, and that certainly is the intention and the manner in which we make these submissions to you, as a means of opening the dialogue, again, borrowing from what has been said already this morning, opening the channels of dialogue, and hopefully having positive, constructive suggestions of moving forward, but also highlighting and flagging up those issues which we say are particularly important and indeed central to the inquiry. So I would also say that the matters that I am going to touch upon, I hope, are not regarded as soft or tangential. We say these are central, and they are founded in law and very established legal principles. So in respect to the Grenfell fire, we, and when I say we, I mean members of the public, we are all living in an age of rolling news where we see events unfold in real time. There is, because we're so exposed to rolling news and events in real time, there is perhaps a tendency for people to become desensitized or inured to what they are seeing. That didn't happen with the Grenfell fire, and that perhaps is illustrative of the nature, the extent and the gravity of what was unfolding before people's eyes. This wasn't just a local tragedy, this wasn't just a national tragedy. Perhaps first and foremost, this represents a number of personal tragedies for the individuals who are here today, those who lost their loved ones, those who survived, those in the immediate vicinity of the area. And grief isn't time limited. We've spoken about delay today, but in fact, anyone who has experienced grief will know that 6 months is actually a relatively short amount of time. People deal with grief in different ways, and the timescales for people are very different. But that has an impact upon how people are engaging and how ready they feel to engage, and what can be done by the process itself to enhance that engagement. The Grenfell fire didn't happen in a vacuum, and so we have to be alive to the realities of the situation, the socio-economic and political realities of what we're dealing with, and looking at what we're dealing with. As I said, local and personal tragedies that have national and worldwide ramifications. Those who are affected come from a diverse, and it's a word I'll be using quite a lot, a diverse social group, a diverse group culturally, racially, ethnically, by religion, by occupation, by financial background, although predominantly it's a working class community. There's a large proportion of those within the community from immigrant backgrounds, some long-standing, some more recent. That makeup, whilst it is in some respects very broad, perhaps is a reason why that community is so nonetheless cohesive, because what can be seen very, very clearly, both from the aftermath, the immediate aftermath of the fire, and in the preceding months, is that this is a very strong, very cohesive community with a clear sense of community and how they are affected. We also have to be very, very much alive to the fact that this disaster happened, as has already been said, within a pocket of one of the richest boroughs in London. London, the richest city in the UK, one of the richest cities in the world, Europe and the world. And that is a reality that cannot be ignored. We welcome, so, what has been said by the inquiry team in terms of putting those directly affected at the heart of this inquiry process. But many still strongly feel that their voices are not being heard. Indeed, it is a real sense from many of those that we represent that in the past their voices have not been heard. And perhaps if those voices had been heard in the past, we wouldn't be here today. So how can the inquiry and the process itself ensure that those voices do not go unheard this time round? As we have said in our submissions, firstly looking at Article 14, it's a prohibition on discrimination, which requires that rights under Article 2 that are engaged in relation to the inquiry must be equally available to all core participants, regardless of social status, disability, ethnic origin, or age. And I should say at this point, pausing for a moment, when looking at the community, I've mentioned a number of different factors. We need also to be very much conversant with the fact that we are looking at a community that has a number of people with disabilities. There is a large proportion within the community of young people, young parents with very young children. We are also looking, and this very much comes into the second point about the public sector equalities duty, we are also looking at a group of individuals who are actually suffering a disability. And I say that because of the trauma that they have experienced as a direct consequence of the fire. It was something that Mr. Mansfield touched upon, and perhaps it's not something that has garnered a lot of traction at the moment, but it will, as I'm sure time progresses and as more comes to light, that clearly there are a lot of people who are still suffering trauma as a result of what they saw, what they experienced, and what their families experienced. And it would be morally repugnant and indeed unlawful for the playing field effectively not to be a level playing field, so that they all can participate and be engaged in a meaningful way. As I said, sir, the question of diversity, it's a word that is used a lot, not just in the legal context, but outside of these walls, within public bodies, within other organisations, and it elicits a number of responses. Sometimes it can elicit the response of eyes being rolled, boxes being ticked. It's important, moreover vital, that when one considers diversity, it is seen as a central and important factor. And we say it's central and important because it actually adds value to the inquiry. It adds value to the decision-making process. It adds value to the actual legal process. Now, again, certainly, we are not suggesting that the inquiry and the inquiry team have not been alive to these issues. There have been a number, I understand, of consultations that have been carried out prior to the inquiry's official opening. However, the attendance has not been at its optimum, and perceptions are important. And unfortunately, those consultation meetings are not perceived as being particularly inclusive at this stage. But that's not a situation that we say is irrevocable. It's one that has to be faced head-on and has to be addressed, but it's one that can be rectified. It's crucial that those in the community feel invested in the process. They feel that and it undermines the confidence if they're not invested in that process. I know, sir, that it is something, as I said, that the inquiry team are alive to, but it's important that it's not simply recognised, but power is given to the words and intention. There is a real perception and a real deeply held feeling amongst many of those that we represent that their effective participation in the inquiry process has been compromised. Those at the heart of the disaster need to feel that they are being listened to, as I say, but also they need to feel that they are not simply passive bystanders to the retelling of their own history and the facts of their own history. Mr. Mansfield has already highlighted and drawn your attention to the report by Dr. Stewart. I would commend that report to the inquiry team. It is a concise but very, in my submission, trenchant piece of work. It explains in very clear terms why issues of diversity are so important in the context of a disaster. They make parallels, or rather Dr. Stewart makes parallels with other inquiries, such as the Lawrence inquiry, and how an awareness of diversity and inclusion was fundamental to enhancing public confidence and community engagement, and ultimately added value, as I say, to the inquiry and the decisions that were made and the reports that were filed. So one has an eye to that question of raising and enhancing public confidence. And that very much, as I said at the outset, ties in with notions of the appointment of a panel and the structure and scope and breadth of the inquiry. They all feed into notions of community engagement and enhancing public confidence. As Dr. Stewart points out at paragraph 5 of her report, the Grenfell Tower inquiry would do well to garner the confidence of the local community to encourage their engagement and feelings of inclusion in the procedures in order to improve the investigation by learning the lessons on the importance of social, cultural diversity from the Stephen Lawrence inquiry. And that perhaps encapsulates, as I said, the points that she makes in that report. In terms of community engagement, as I said, so the structure and having those who represent or reflect the community as a real part of the structure of the process, again, will enhance that level of confidence and that feeling of engagement. So I won't repeat them because they're there in the submissions that we drafted on behalf of Birnberg Peirce. And I think they've already been alluded to this morning, a number of authorities, which deal with that question of putting the victims and next of kin at the centre of matters, but also this question of humanity, dignity and respect. And they're three small words, but they have tremendous impact. These are individuals, many of whom are sitting at the back of the room, who ask for, and it's not a big ask, they ask for dignity, humanity and respect in the way that they are treated and the way in which they are provided with engagement and an opportunity to engage in this process. Now, that involves not simply the legal and structural matters that we have dealt with, but also looking at the individuals and putting in appropriate measures to ensure their well-being, both physical, emotional and psychological. The inquiry should ensure that next of kin, survivors and residents are afforded special consideration and care to avoid being further traumatised by the process itself. And that is something so that one has seen in a number of different inquiries and inquests where individuals say that the actual legal process itself can be quite dehumanising and traumatising. So that brings me then on to the question of venue. Obviously, we are in this room. It is stuffy, perhaps to say the least. It has become more and more so as the morning and the afternoon has gone on. It is not perhaps the most ideal from the legal point of view, but put the lawyers to one side. I make my submissions on the venue primarily in respect of those that we represent. Initially, the inquiry was, of course, going to be at the Connaught Rooms, and Birnberg Peirce made representations in relation to that and why those provisions were inadequate. And those representations still hold in regards to the new venue, this venue. I note from paragraph 62 of Council's statement that it is said why the venue was chosen, and I quote, "The venue has been selected because of its central location, good transport links to the Latimer Road area, and suitable disabled provisions. It is large and well provisioned enough for the operation of the inquiry and the accommodation of a reasonable number of those wishing to attend the hearings." That may be true to an extent. Its central location, one would say central primarily to the lawyers, and one could even demarcate it even further, perhaps central to the bar, and not necessarily central to a lot of the solicitors who represent those members of those next of kin, residents and survivors. In terms of its location, in terms of the building itself, we represent, as I said, a diverse group of people, many young parents, those with young children, those with disabilities. Travelling to and from, if they want to fully engage and be physically here, has a cost, a financial cost. Central London, lunchtime provisions for food. In terms of the engagement with the legal teams, conference rooms, facilities for that. Ensuring that those who come can participate because of they may need interpreters, they may need other specific needs to that individual. Those are matters that are important. But overriding all of that, many of those that we represent say that the choice of venue, and perhaps had there been a greater level of discussion and engagement with the community, may have resulted in a different choice. They have been looking themselves at alternatives in the locality of the area. At the moment, amongst those that have been identified is a local college as an alternative venue. It would need to be kitted out effectively in terms of provisions to make it the home of the inquiry, but there is time to do that.
I think they'd also have to be able to make available enough room for long enough, wouldn't they?
So yes.
Could that be a difficulty? I don't
that
know.
may be a difficulty, but again, it is not insurmountable. As has already been mentioned, there are many of us here who have been involved in similar, certainly out of London in my case, long-running inquests in which the question of venue was something that had to be revisited and was overcome. There is time to do that, and certainly what we would ask at this stage is that dialogue is opened, and there are options that need to be looked at, whether they are viable, So for the reasons you've mentioned.
You mentioned the college. Is that Kensington and Chelsea College?
Yes.
Yes, thank you. All right.
So those are the kind of things that would need to be looked at. The viability in terms of long term, because clearly we are looking at well into the future in terms of how long this inquiry will run and to its conclusion. But those are not insurmountable, and we have time, sir, to do that. And it's something that very much has exercised those within the community, the question of venue. And certainly they would not want it to be seen as an add-on, as I said, a tangential or a side issue compared to the very, very important legal matters that you've heard about this morning and will hear about further in due course. Because it affects, again, going back to the question of participation and engagement and confidence, if one cannot physically get to the inquiry, or once one is there, you can't physically participate because of a lack of services or a lack of room or just financially, the prospect of bringing a small child, having to find food for that child. These are practical matters, which I know others will address you on, but they feed into the whole question of venue. So we would certainly say the time is now and the opportunity is here for us to look at this afresh. There is one caveat in relation to venue that I know that some of the residents, survivors, next of kin are concerned about another council building being used. But I say that as a caveat, but the overall position is that the venue, they say, should be one locally to allow better access for individual members of the public as well as those we represent. So I think, in fact, I've covered those four matters, keeping in the trend of this morning within time.
Yes, you've done very well. Thank you very much. Yes. Well, thank you very much for your submissions. Now, Mr. Steen, I think you are